Metz is committed, don't clap yet, there'll be more to clap about. Jill is committed to serving the legal needs of the LGBTQ community, a challenging and ever-changing legal field that includes gay and lesbian family law, civil union law, adoption, estate planning, business law, real estate law, and probate law. Jill is the president of the board of directors for the American Civil Liberties Union, the ACLU of Illinois, and a cooperating attorney with the ACLU. Her former work as chair of the Lesbian and Gay Rights Project of the ACLU and legislative liaison for the Lesbian and Gay Rights Committee of the Chicago Bar Association have put her at the forefront of the changing laws that affect the LGBTQ community, leading to her induction into the City of Chicago's Lesbian and Gay Hall of Fame. So without further ado, Jill Metz.
I want to thank the Center on Halsted for putting together this evening. I think it's important to look at where we've come over this past year, which is what I'm going to cover. Really looking over the past year is really from Windsor to Wisconsin, so the two W's. The Edie Windsor case filed by the ACLU of Illinois, which you probably all know about Edie Windsor case, so I'll try to be brief. The ACLU filed this case challenging the federal government's discrimination against same-sex couples' marriages. I think we all know that Edie Windsor was successful. The federal government ban on recognition of same-sex marriages has been overturned, and she received back $365,000 in tax money that she wouldn't have had to pay on the estate of her loved Theo, who died after they were married. Edie won that case, and the world has never been the same. If you follow the news at all, you can tell how this past year has just accelerated in the acceptance of our relationships as being normal. Since this conversation is called Windsor to Wisconsin, I'm going to use the Wisconsin judge's opinion language to demonstrate how the world is no longer the same as it was a year ago. Judge Barbara Crome concluded in her Wisconsin decision about the marriage ban case that was filed there, says that the interference with plaintiffs' rights to marry in violation of the Due Process Clause and discriminates against plaintiffs on the basis of sexual orientation violates the Equal Protection Clause of the U.S. Constitution. So that very powerful document has now come to include our community. She also went on to say what I think are some important words about gay and lesbians in society in general. She said to decide the case in favor of the plaintiffs is not necessarily, as some had suggested, and she really means the dissenting opinion in the Supreme Court, that it would cast all people who cling to traditional beliefs about the nature of marriage in the role of either bigots or superstitious fools. That language is from Judge Alito's minority opinion. Or to adjudge those who oppose same-sex marriage enemy of the human race, which is a quote from Judge Scalia in his dissenting opinion in Windsor. Rather, and this is really powerful, it is necessary to conclude only that the state may not intrude upon, without adequate justification, on certain fundamental decisions made by individuals. And that when the state does impose such sanctions or restrictions on these important matters, it must do so in an even-handed manner. The case is not about whether marriage between same-sex couples are consistent or inconsistent with teaching of particular religions, whether such marriages are moral or immoral, or whether they are something that should be encouraged or discouraged. Quite simply, this case is about liberty and equality, the two cornerstones of our rights protected by the U.S. Constitution. You know, that's what I love about the law. That language is really powerful and really beautiful. And that Constitution has come to protect us now also. How very simple that statement is, how clear it is. This Wisconsin opinion also very simply stated why the decision to take on the battle of marriage was a fundamental building block for equality for gays and lesbians. People have often said, why marriage? Why not something else? I'm going to tell you why. She says the parties do agree about at least one thing, which is the central role marriage plays in American society. It is a defining rite of passage by one of the most important events in millions of people's lives. There are countless government benefits tied to marriage, but these are only practical concerns, and only one of the reasons that marriage is an exalted privileged civil status. Exalted privileged civil status. We view marriage as an essential to the pursuit of happiness, one of the inalienable rights in the Declaration of Independence. Marriage is not merely an accumulation of benefits, it's a fundamental mark of citizenship. Think about that. It's a fundamental mark of citizenship. Thus, by refusing to extend marriage to plaintiffs in this case, defendants are not only withholding the benefits such as tax credits and marital property rights, but also denying equal citizenship to the plaintiffs. That's what we're fighting for. And the judges across the United States are getting it. When the Windsor case was decided June 26, 2013, one day towards the end of this month, a year ago, there were 13 states and the District of Columbia that had legalized same-sex marriage. The federal government did not recognize same-sex marriage, and all of the benefits and rights and obligations that came with that were not available to us. 1 year later, we have 21 states now and the District of Columbia, and more than 44% of the United States population lives in marriage states, and Illinois has marriage equality. The New York Governor, Chris Christie, decided not to fight the battle in his state and stop the battle against same-sex marriage in New Jersey. And every state in the Union has a lawsuit pending challenging the ban on same-sex marriage. North Dakota was the last state, and that lawsuit was filed about a week or so ago, 2 weeks ago. It's really been an amazing year. So whether people are going to do it in a legislative process like we did here in Illinois, with the courts accelerating it, or through federal action or state court action, the advance has been, I think, faster than any of us could have imagined over this past year. There hasn't been a single case decided at the trial court level that has not found the ban unconstitutional. Not a single case so far. There have been 11 of them decided, and in all 11 cases, the ban has been found unconstitutional. Each of these cases has something slightly uniquely different that happened in it, and so I'm going to kind of run through it. In Utah, after the ban was overturned, and this is kind of another pattern that's kind of happening across the country, which is the judges, whether on purpose or not, have opened the door to marriage happening immediately in those states in a lot of cases by either not staying their decision of overturning the ban or by just holding their final opinion and clerks issuing marriage licenses. So in Utah, after the ban was overturned, that judge didn't stay the opinion. So marriage was legal in Utah until the appellate court there, federal appellate court, stopped it. And during that time period, over 1,000 couples married. And the federal government has recently said they're recognizing all these marriages in all these states. So once you've got a marriage license and it's been registered, just like we're doing here in Illinois, those are valid marriages as far as the federal government is concerned. So that happened in Utah. In Oklahoma, the court declared the ban unconstitutional. You will also realize that we're not just talking about liberal East or liberal West or even kind of our middle liberal Iowa and Illinois anymore. We're also talking about some more conservative states. In Kentucky, the court declared the ban unconstitutional, and the Attorney General in that state decided not to pursue any appellate review of the decision, figuring that it was not going to be successful. Unfortunately, the governor in Kentucky has hired outside counsel and is pursuing that litigation. The judge in that court says that the law treats gays and lesbians persons differently in a way that demeans them. There's another judge that really gets exactly what's going on. Listen to how important that language is going to be. Virginia, the federal court overturned the ban. In Texas, the federal court overturned the ban, saying there's no legitimate government purpose in the ban on same-sex marriage. Remember, this is the government, this isn't churches, this is the government. The Michigan court actually had a trial, which is very interesting because we have been wanting a trial for a long time. Because I'm a trial court lawyer, and I know that once you actually put the evidence on and examine the kind of arguments that people have been making about our relationships and the ban on marriage, there is no legitimate government purpose in that. So Michigan held a trial, 2 weeks of trial, put on all the evidence, had the experts come, crazy expert with the one study that nobody thinks is a legitimate research study at all, but they continue to use it. They tried to use it here in Illinois. And they decided that they had no legitimate purpose for which they could assert a ban. The judge in that case also allowed the order to stay open, so she didn't issue a final ruling. And in that time period, court clerks stayed open on Saturday, so people went and got marriage licenses. They waived the holding period, so people got married. They stayed open, so I think it lasted about 5 days. So there were marriage licenses issued, and people in Michigan now married. That case actually started because two women wanted to formalize their family with their children, and Michigan didn't allow non-married people to marry. To adopt children, so they wouldn't do their adoption there. So that's the fact pattern that started that case. In Ohio, this is really fascinating how fast things are moving. In Ohio, there's a poll that shows over 50% of the voters now support legalization, where just 8 years before they passed a constitutional ban on same-sex marriage, 8 years. The court in Ohio has now ruled that marriages from other states must be recognized in Ohio. They don't have a law in Ohio yet, either by court action or by legislative action, that allows people to marry. But if you were married in another state and you moved to Ohio, or you came back to Ohio, that marriage would have to be recognized. Arkansas. This is a state court judge in Arkansas. The rest of these cases have all been federal court cases. A state court case in Arkansas said that the ban couldn't stand, and before a stay was put in place by the appellate court there, over 400 same-sex couples married. In Idaho, a federal court ruled against the ban, and before a stay, couples married in Idaho. Again, rushing to the clerk's office and getting those marriage licenses by clerks that got it also. In Oregon, the ban was struck down, and no official appealed. Again, a private party tried to intervene like they did in the Prop 8 case in California, but the appellate court has said they don't have standing to intervene, and so that since there isn't any government official appealing that case, Oregon has become the 20th state with marriage. In Pennsylvania, the federal court overturned the ban, and the Attorney General and the Republican governor both believed it would be extremely unlikely to succeed, so Pennsylvania has become the 21st state. So we are seeing not only legislative process like here in Illinois, but legal process across the states, and then the political process, where in Kentucky we have half of the executive branch saying no. In Pennsylvania we have the whole executive branch saying no, and so we're not having appeals of those cases. Another interesting thing that's been going on, and I find it kind of amusing because I'm not a Scalia fan, the federal court judges have been using Judge Scalia's language in the dissent to overturn the bans. And I think it's been kind of amusing, and I think they're kind of having fun, so I'm going to read you some of it. So in Virginia, Judge Wright Allen wrote, "In Windsor, our Constitution was invoked to protect the individual rights of gay and lesbian citizens, and the propriety of such protections led to the upholding of state laws against the conflicting federal law. The propriety of invoking such protections remains compelling when faced with the task of evaluating the constitutionality of state laws. This propriety is described eloquently in a dissent opinion authored by Honorable Anton Scalia." As he said, the real rationale of the Windsor opinion is that DOMA is motivated by bare desire to harm couples in same-sex marriages. How easy it is indeed, how inevitable to reach the same conclusion with regard to state laws denying same-sex couples marital status. I like it a lot that they're using his words against him. In Kentucky, Judge Hayburn observed, as she overturned the DOMA, overturned the ban in Kentucky also, that DOMA laid the foundation, and in his dissent, he said that Windsor indicated the way the Supreme Court would review future cases involving same-sex marriage, meaning that he didn't believe that once they decided the E.D. Windsor case that they would ever turn back, and we certainly hope that that's true, and I think it probably is. In Utah, the judge there said, "The court agrees with Justice Scalia's interpretation of Windsor and finds that the important federal concerns at issue there are nevertheless insufficient to save a state law prohibition that denies plaintiffs the right to due process and equal protection under the law." In Ohio, again, the judge says the same kind of language. And in Texas, and I don't know whether you saw the Huffington Post article, where the title was Judge Scalia Screwed Texas, because the federal judge in Texas used his own words in his dissent again to say, look, we're not going to be able to prove that there's any legitimate state purpose for these bans, and if you can't prove there's a legitimate state purpose, as the federal court has already said, we're not going to uphold them, and so we might as well move forward. So that's what's been going on there. The courts have been moving very fast, but there's a word of caution that we all need to know that this work is not over. So what's been moving fast is on the trial court level. All of these cases that I've cited, the 11 cases and the rest of the cases that have been filed in the state and federal courts, will have to go through an appellate court process, one at a state level, but mostly at the federal levels. And then those cases could potentially end up at the Supreme Court. So we all probably think that's where it's going to end up, as it did with interracial marriage. But so far we're 100% in our victories, but I don't think it would surprise me at all, and probably wouldn't surprise you, that we're going to have some appellate court that will find some rationale and some state for saying that there's a difference between our relationships and heterosexual people's relationships in a way that the government has an interest in making that discriminatory decision. So then it'll go back to the Supreme Court again. The good news is that all these cases are moving very fast. So all of these cases have on an expedited basis, so we're not going to wait very long. We'll have opinions probably in the fall, which means the Supreme Court can take the case yet in 2014, make a decision in 2014, but probably unlikely. We're probably looking more like 2015. So the other thing that happened this past year, well, first, the other thing that happened this last year is that the federal laws, every federal law that could be done by an administrative ruling, ruled that marriages would be recognized in those different programs that federal rights are connected to, or federal benefits. And they made mostly the rulings that it's based on the place of celebration, so the place of the marriage. So if you were married legally in some state, even though your state doesn't recognize that marriage, for federal purposes, that marriage will be recognized. There's a few exceptions, and those exceptions are really where the state administers those programs. Some of them are kind of significant, Social Security benefits being one of them, but most of the others are all the kinds of things you would expect where the federal government would recognize. So you can file joint tax returns. You no longer have to pay the taxes on employment benefits like health insurance. So there's a couple of interesting quirks here in Illinois. If you were in a civil union and instead of getting a marriage, you went back and did the upgrade from your civil union to a marriage, your marriage date is back to the date of your civil union. So that could be 2011 when we got civil unions here in Illinois. So you could go back and amend those tax returns for those years and actually get a tax credit back, not having to pay taxes on those employment benefits that you got would be one of the benefits. So if you are people who are in that kind of category, that would be something you want to look at. So the things that kind of surprise people a little bit about, as we've been moving so quickly forward, is that not always does being married work out for tax purposes. So I caution you to not be so enthusiastic to think everybody's going to have a tax return that's less expensive than the tax return that you had before. But it was very good news that all of the federal government laws moved very quickly. One of the things I want to say about what went on this past year, or what's still going on now, is that the lawsuits that were filed by a number of organizations, the ACLU, Lambda, the National Center for Lesbian Rights, the Southern Poverty Law Center, and a number of private lawyers and private firms. So this has really been a huge undertaking by both all those nonprofit organizations and by individual lawyers and law firms. And if you look at the list of people who are involved in those law firms, it has been hundreds and thousands of hours spent on those law firms, making sure that the decisions were the way that we wanted them to be. So I'm going to talk for a few minutes about challenges, because besides continuing and finishing the work that we have to do to make sure marriage actually expands through all 50 states, and if there's any challenges anywhere that they aren't successful. We have some employment discrimination problems. I've been telling people that Pennsylvania now has marriage, but it has no protections against discrimination for your employment. So you could decide to get married, submit your marriage license so your spouse could get benefits, and you could be fired. And there's nothing illegal in Pennsylvania about that. There are only 19 states that have protections. We have 21 states now with marriages, only 19 states with protections, and we have even fewer states that have any transgender protections. Illinois was very successful in our inclusion in the Human Rights Act, that we include both gender identity and sexual identity. And so we have protections here in Illinois. The Human Rights Act is an extremely powerful piece of legislation here in Illinois, and it's something that the national ENDA law would also help all the states. But here in Illinois, if you're not familiar with the fact that we have this Human Rights Act, it's really a powerful piece of legislation, because all of the conversation that was going on in Springfield about whether people would have to allow you to rent their facility for your reception or for your wedding really was about the Human Rights Act. It wasn't really about the marriage bill. Religious institutions are exempt, which is appropriate, because they should be able to make decisions based on their religious beliefs, but that's it. We don't allow our florists to decide they're not going to do flowers for us, and we don't allow bakers to decide that they're going to not make our wedding cake, and we're not going to allow B&Bs to say you can't come here and have your reception, because that's against our Human Rights Act. We have a law about public accommodation, and it is very broad. It includes services, it includes facilities, it's very broad, and it includes us. And we have to remember that if someone should decide that that's not true, we don't have to talk to them about the marriage law. We have to talk to them about the human rights law, because the words are powerful. Human rights law, and so we have to make sure that we continue with all the rest of our states to make sure that we have protections for all those kind of fundamental rights. The last area that I think we have to be concerned about, and we have seen some of it here in Illinois already, is using religion to discriminate. So this has really come up a lot in the reproductive rights area, where pharmacists and hospitals have decided that they don't have to provide proper medical care because of their religious beliefs. And so they turn women away for having abortions, they turn women away who have pregnancies that are not going to be successful and are endangering women's lives, and pharmacies not providing contraceptive care. So we've already seen these kinds of issues arise. And they are going to come up because people who make wedding cakes are going to say, my religion says that gay marriages are an abomination, or whatever they want to say. I don't believe in them. And they're going to assert their religious beliefs. And we have to fight back about those things, because if you provide a public service, we in our Human Rights Act have already said that that doesn't allow you to discriminate. And we have fundamental principles in the United States about the separation of church and state, which means that you can hold your own private beliefs, but you cannot, in your job, assert those private beliefs to not perform your job. And we have government employees that are attempting to do this also. So it is going to be a big fight. It is the fight on the horizon. We have to really watch that Hobby Lobby case before the Supreme Court very carefully. We're hoping that they don't decide corporations have religious rights. But if they decide corporations have religious rights, that they do it in a very narrow fashion about this particular family in some way, because they do really act in many ways upon their religious beliefs. But that's an area that's going to cause a lot of problems for women's health care as well as for LGBT folks. So the last thing I want to talk about is how you can make a difference. What's the next steps that you can do? One of the things that I really believe in very strongly is being part of an organization. So whatever the organization is that you think works best for you, mine's the ACLU, it's been the ACLU for a very long time. I thought every lawyer should be a member of the ACLU. Very effective organization, but there are other organizations out there. Become a member. Membership matters. The NRA has 1 million members, and they use that 1 million member number to beat people over the heads with their beliefs. We need to have 1 million members who have our beliefs, and that only happens through memberships. So it's not expensive, so become a member. If you can become a donor, even better. If you want to march in the Gay Pride Parade with an organization, there's lots of organizations looking for volunteers to be in the Gay Pride Parade, and that matters, because those show impact also. So those are the things that you can do. The legislative process is a legislative process. If you have opinions about who should be our next governor, you should read about what they believe about the things that affect your life. Be careful about those things. Watch the judicial ballots. We elect judges in Illinois, and people don't pay attention. So you get all the way down to the end of that ballot, and it's really long, and there's like a gazillion judges on it. There's an alliance of Illinois bar associations that rate judges, and they will give you help. So if you don't have any idea who's a good judge or a bad judge, use that. They're not prejudiced. They're not picking on people. They're not throwing off people based on any particular views or race considerations. They're throwing off judges who are using their own prejudices to make bad decisions, or not running courtrooms efficiently, or not doing their jobs properly. So that's a place that you can make a huge difference since we elect our judges in Illinois. So I can take a few questions. You've had something.
Does that include the Supreme Court in Illinois also elected?
Yes, we elect everybody in Illinois. Appellate court judges, Supreme Court judges, we elect everybody. We have another group of judges that we don't elect. Judges elect those judges. Those are associate judges. But we've got plenty of judges. We can make a huge difference. It makes a difference. I'll give you just one brief example, then I'll stop. You all probably know Nancy Katz. Nancy Katz is a judge here in Cook County. When I started practicing almost 36 years ago, there were very few women judges. There were very few lawyers in the trial courtrooms. And the judges could all go back in their chambers and laugh about gay issues and chuckle and, boy, kind of slap each other on the back. That can't happen anymore, because there's judges like Nancy Katz that are in all of those meetings, and judges who are our friends who may not be gay or lesbian themselves. And so those kinds of things don't happen anymore, and they raise real issues with the judges. I was talking before about trans issues. There's lots of work happening among the judges so that they can understand trans issues and not laugh and not think they're weird and not rule against them based on their gut decisions instead of actually facts. So that's a really important thing that you can do. I may be giving you all examples connected with the legal world because that's my role. So thank you very much for coming.